Hello. Hello. Mic testing. Hello. 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 Mic testing. Hello.
Serial number 38 may not. I'm for the respondent institution may not. Last time may not, we had made a submission that may not the proposal for appointment of appellant may not is been already been, respondent is been sent. This is challenging the appointment made by the medical institution where she is found to be more meritorious than the appellant. We made a submission that since there is one more vacant post, we'll make a arrangement for Manod, posting respondent also. The proposal is already been sent to Manod governing council, since appointing authority is the governing council.
Okay, you inform the other side.
Please.
Huh?
Uh,
Relist. March.
Obliged.
Inform the other side.
Obliged.
One ನಿಮಿಷ. ಯಾವುದು? ಅದಾಯ್ತು ಅವ್ರದ್ದು. ಅದು ಮುಗಿಸಿದ್ವಲ್ಲ? Affidavit filed. Commissioner of Excise Yard. He said affidavit. Language in part 15 and 16 of the affidavit 1/10/2024. And the said statements are withdrawn. ಅದಕ್ಕಿಂತ ಮುಂಚೆ now compliance is
Yes.
that AGA has filed a memo and submits that the vehicle has been released and hence proceedings may be dropped. Next, counsel for the complainant however submits that the vehicle is in a very bad condition. However, in the present proceedings, we cannot comment regarding such grievance of the petitioner which is kept open. In light of the proceedings having, in light of the complaints having been complete, proceedings are dropped. Next, the Koned's paragraph. It is while passing final order dropping the proceedings, we have come across the affidavit dated 1/10/2024 and found that the language used at para 15 and 16 are inappropriate language to be used in an affidavit filed in contempt proceedings. Accordingly, proceedings are dropped. Yes.
Number 11. Geeta, this matter has been settled in the trial court.
Third counsel for the appellant has filed a memo which reads as hereunder. In light of the same, appeal is disposed of as not calling for any adjudication.
Yes, my lord.
Huh? That's
Yes.
it's settled there only.
It's settled there itself, my lord, between both the parties.
So we dispose this off.
And yes, my lord, it can be disposed of. Like,
Pending is disposed of as not calling for adjudication.
Serial number 33, my lords, the other side has taken time, my lord, because they got interim order, my lords.
Kya serial number?
38, my lords, 38, my lords. Regarding the appointment of in BRIMS Institute, my lords, the already honorable court granted stay, my lords, subject to making representation from the uh, BRIMS authorities to the state, my lords. But they have not made any.
We have already sent it to the governing council. Because in this case, my lord, governing council is my lord, headed by the secretary of my lord, medical education. It has to be my lord, who will be the chairman of the governing council.
No,
I being
just-
the head
no.
of the institution.
No, just tell us what the facts are.
Regarding the appointment of psychological posting before the BRIMS Institute, my lord.
Who are you now? You are
Respond number 4, my lord. So,
respondent 4 in the writ appeal.
yes, my lord. In the writ I also petition, my lord.
In the you had filed the petition. Challenging selection.
Yes,
So what happened in that writ petition?
it was allowed and the same came to be, our petition came to be allowed and to appoint in the place of appellant, my lords.
So you were selected, an appointment of you in place of the
Appellant.
appellant was the respondent there.
Yes.
So then what has happened? Now on what ground it was allowed? That you were more meritorious.
Yes, more meritorious and after one selection process is started, my lords, they have attempted to made some advertisement, my lord. That is not come in the way of now recently Supreme Court has held that, my lords, any changes will not affect the first notification, my lord. That the larger bench.
Correct. So now what is the interim order now passed?
Now, my lord, interim order has passed stating that there is a delay in filing a writ petition, my lord. There is no such delay, my lord. As per I will convince your lordship, my lord, there is no such delay. We obtained some documents from RTI because there was no any preliminary notification was published or final notification was published, my lord. Only when we got obtained from RTI, we came to know that suddenly in one day they issued notification and then thereafter they appointed, my lord. And it was not meritorious also. After that, honorable court in writ appeal stayed, my lord, subject to stating that BRIMS they may take the in between appointment for the respondent number 4 year in, my lords. But that will not taken any progress, my lord, because since from 6 months, my lords, they have not made any attempt, my lord. Simply they are taking.
27,
Now
11,
both are.
No, just a minute. 27, 11, 24.
Yes.
Read that order.
Learned Council for Respond number 1 and 2 files a memo along with publication dated 21st November 2024 made by the director of the respondent institution to the director of the medical education. Learned Council submits that efforts are being made to ensure respond number 4 is appointed as psychiatrist child in the vacant post in the respondent institution. However, the decision of appointing a person for professor psychology is possible only at the hands of governing council, and therefore the process may take a little more time. Release the matter on 16 December 2024.
One post is already vacant. May I make one more?
No, just 1 minute. Now you appear for the
I
institution.
appear for the institution on behalf of the director. The post which is vacant, my lord, the appointing authority is the governing council. Not that I am only, my lord, the administrative head of the institution. The governing council has to take a call. Chairman will be, my lord, the secretary of medical education, and it will be, my lord, the all other members, my lord, 5 members, where I will be a member secretary also. I have already, my lord, placed everything on record before, my lord, the director of medical education. Now a meeting has to be conveyed of governing council, which is taking some time because of, my lord, the session before, my lord, the Belgaum and all. My lord, in the meanwhile, I have made. I in fact communicated the appellant council for respondent also. The post is vacant. If, my lord, she is ready to, my lord, discharge her duties, we are ready to take her on contract basis. Still, my lord, governing council take a decision. if she really in need of a manot job, I am ready to pass order. That order I can pass manot as a director of the institution. Interim measure ಮಾಡಬಹುದು ನಾವು. Till governing council takes a decision, I can make arrangement manot so that she can discharge her duties.
Now you place that on record what proposal you have sent.
Yes, Manoj.
We'll have it on.
Our bad andiduk nan sunnadu sir. Otherwise I am going to file update also.
Two things.
Okay.
One, you place on record
Yes.
what you are expressing now.
Yes.
That till the governing council takes a
Time
decision.
ಹೋಗ್ತಾ ಇದೆ ಅಂತ ಅದಕ್ಕಾಗಿ.
Alla, correct. So
Yes.
you place it on record.
Please.
That one, that it has been sent to the governing
Yes.
council, which date,
Yes.
communication.
Yes.
Two, that in the interregnum, as the governing council may take some time, an offer is made, and we leave it to the court to pass appropriate direction.
Illondu difficulty, I am not a appointing authority. If I file an affidavit to the
Contract,
court,
contract.
then Manoj, I may
Alla,
face
memo. Alla,
why you are giving all this.
No, we will ask you, we will pass an order now,
Please.
saying that there was a direction. Governing council may consider appointment of respondent number 4. We'll ask you in writing to give your response. In response to that, you make out a proposal.
Please.
Then we will see what is to be done.
Oblige.
Let us see.
My only intention was Manoj.
No, correct. Absolutely. The noted the order dated 11/11/2024, wherein this honorable court in the interregnum had passed a direction to respondent number 2 to consider appointment of respondent number 4 in any other vacant post in the institution. Full stop. Counsel for the respondent number 4 submits that there is no visible progress, and respondent number 2 has not placed before this court their response to steps taken pursuant to the observation of 11/11/2024. Full stop. Learned counsel for respondent number 2 to place on record their response to the observations in the order dated 11/11/2024.
That is filed, Manoj. Along with the affidavit, I have filed.
And steps taken till date. Steps taken till date. Full stop. Relist the matter on Monday.
Monday will be too short.
Before the roster changes, Haki.
Before
so that,
the roster.
So when you want? Sir?
May on 27th, may I request?
27th.
Oblige.
On 27th. Just see something can be done.
Yes, yes.
Gate is smiling quietly.
Malad.
Smiling quietly.
No, my lord. Because it is ultimately he has to accommodate both of us, my lord. I am rendering services from 2018.
Let us see.
My services are confirmed.
But not meritorious.
Meritorious.
Yes.
Yes, let's see. No one be there. First, I think.
Seat number 48, Anil Kumar Navadigi.
Call Mr. Nowadays. Is there a... Yes, Anil, only on that point. Accused number 5 and 6.
Yes, my lords. A question was posed on the last date of hearing
Yes.
as to whether the charge under section 149 can be converted or altered into section 34 of IPC. The Supreme Court has said that it can very well be converted into 34 if some of the accused are acquitted and there remain only accused less than five numbers. So on that point, my lords, may I pass on the decision of the Supreme Court? The relevant paragraphs would start from para 10, my lords.
Ah.
The High Court in appeal reappraised the entire evidence and took further notice of the complaint's admission that three of the accused, namely Rajinder, Hawa Singh and Biro alias Virender, had arrived at the scene of occurrence after he had already suffered injuries from the other accused. Sensing the possibility that late arriving of the accused might have been named only to widen the net and settle past scores, the High Court extended benefit of doubt to Rajinder, Hawa Singh and Biro and acquitted them of all charges. As regards the present three appellants, Rotas, Sanjay and Bijender, the High Court found no ground of interference with their conviction, though it reduced the quantum of sentence under the charge of Section 307 of IPC from 7 years to 5, with a combined additional fine of rupees 1 lakh to be paid to the victim complainant. The three remaining convicts, namely Rotas, and have assailed their conviction and sentence through these two criminals. We have heard the paragraph 12. We have heard the learned counsel for the appellants at considerable length and have
14. Come to para 14.
14. We have given our thoughtful consideration to all the issues raised on behalf of the appellants. We first deem it appropriate to avert to the contention whether a charge framed with the assistance of section 149 IPC can be later converted to one read with section 34 IPC or even a simpliciter individual crime. The first part would be applicable to the case on hand. Second, whether lack of independent witnesses to a violent crime would undermine the prosecution case and whether closely related witnesses can be relied upon in such instances. And third, whether leniency ought to be shown to the present appellants given the extended period of liberty which they have enjoyed since being released on bail. Framing of charge and its subsequent alteration. The primary attack on the judgment of the High Court by the learned counsel for the appellants is on a question of law, which although seems interesting at first, but turns out to be a superficial upon a deeper consideration. The oversight regarding section 148 and 149 of IPC as highlighted by the appellants is indeed inescapable. Before the members of an unlawful assembly can be vicariously held guilty of an offence committed in furtherance of common object, it is necessary to establish that not less than 5 persons, as mandatorily prescribed under section 149 read with 149 of IPC, had actually participated in the occurrence. It is not uncommon, like in the present facts, when although the number of accused is more than 5 at the time of charge sheeting, but owing to acquittals of some of them over the course of trial, the remainder number of accused falls below 5. It may be true in such cases, as rightly urged by the appellants, that the charge under section 148 and 149 IPC would not survive. This does not, however, imply that courts cannot alter the charge and seek the aid of section 34 IPC if there is a common intention, or that they cannot assess whether an accused independently satisfies the ingredients of a particular offence. Section 211 to 224 of CRPC, which deal with framing of charges in criminal trials, give significant flexibility to courts to alter and rectify the charges. The only controlling objective while deciding on alteration is to whether new charge would cause prejudice to the accused. Say if he were to be taken by surprise of if the belated change would affect his defense strategy. The emphasis of chapter
16 of 17 of CRPC is thus to give a full and proper opportunity to the defense, but at the same time to ensure that justice is not defeated by mere technicalities. Similarly, very important, my lord, section 386 of CRPC bestows upon even upon the appellate court such wide powers to make amendments to the charges which may have been erroneously framed earlier. Further, improper or non-framing of charge by itself is not a ground of acquittal under section 364 of the CRPC. It must be necessarily be shown that failure of justice has been caused, in which case a retrial may be ordered. The contention of the appellants to the contrary is nothing but hypertechnical. Lords, again at para 19, the classic judgment of Karnal Singh versus State of Punjab has been quoted. Lord, in fact, the law on this point has continuously been delved into and reiterated by this court from time to time. A three-judge bench of this court in Karnal Singh versus State of Punjab held that it is true there is a substantial difference between the two sections, but as observed by Lord Samar in Barendra Kumar Ghosh versus Emperor, they also to some extent overlap, and it is a question to be determined on the facts of each case whether the charge under section 49 overlaps the ground covered by section 34. If the common object, which is the subject matter of the charge under section 149, does not necessarily involve a common intention, then the substitution of section 34 for section 149 might result in prejudice to the accused and ought not therefore be permitted. But if the facts to be proved and the circumstance and the evidence to be adduced with reference to the charge under section 149 would be the same if the charge were under section 34, then the failure to charge the accused under section 34 could not result in any prejudice, and in such cases the substitution of section 34 for section 149 must be held to be a formal matter. So, my lords, if the two accused go out, accused numbers 5 and 6, lords, they have acted in concert, all the four accused. I am pleading against the interest of my clients, that is accused numbers 1 to 4. But I would like to be fair. They have acted in concert. There was premeditation on their part, and there is one injured in this case who has deposed about the
PW8.
PW4 Mayappa. He's in PW8. He is also an eyewitness.
So
but
PW8 deposes that you are.
He speaks about 1 to 4 initially, and later on he adds that woman accused 2 were part of the incident, part of the assault. My lords, it appears to be an afterthought.
If this court believes the evidence of PW8, then only against accused number
1 to 4. He being an independent witness. PWs 1 and 4 after, of course, they are interested witness. They have interest in the outcome of the case, and they have deposed against all the 6 accused. But when we assess the evidence of PW8, Kenchappa Rolli, Lord, he is an independent eyewitness. He initially names 1 to 4, then as an afterthought adds accused numbers 5 and 6. The participation of accused numbers 5 and 6 become very.
Opinion of the doctor who conducted the autopsy that the major injuries are caused by that axe.
Axe. Yes, my lords. He, in fact, he says such weapons can cause the injuries as noted in the postmortem examination report, and
one of the MO is
a stone, 3 axes, and 2 bamboo sticks.
Handle of the axe, also one of the weapon.
Yes, not 3 axes, 1 handle of the axe, 2 axes, 1 stone, and 2 bamboo sticks.
Correct.
inference could be gathered that those injuries, contusion injuries are caused with the wooden handle of the.
Handle of the axe and even stone.
One submission.
1 minute, let me finish. She is appearing for A1 and A6, 1 and 6.
After sir, in that one.
So,
Yes. Let us see. What
Yes.
is your submission?
Lords, in additional to sir's argument, I want to add few points, my lords. My lords, according, I am for appellant number 1 and 6, my lords. My
Accused
lordships.
number 1 and 6.
1 and 6, my lordships. My lordships, according to section 26 of Indian Evidence Act, now it is 23 of Indian, my lords, confession by accused persons whilst in custody of police not to be proved against him, my lord. The 26th section says, my lords. Here in our case, my lords, confessions made by the appellants before the police officer in the custody of the police, my lords, and those in the presence of whose witnesses the confessions were made, those witnesses turned into hostile, my lordships. How could the trial court can rely on such kind of evidence, my lordships? And
Now the police initially laid hand on you based on the voluntary statement or eyewitness statement?
those are punch witnesses, my lords.
For recovery.
In their presence,
You are arguing
for
on
recovery, my
recovery
lords.
of
For
material of-
recovery, my lords. It is alleged that at 8 a.m. in the morning, the incident has taken place. Immediately on the same day, all the appellants were arrested around evening 7:30 p.m., my lordship. Same day, the Pancha inquest, all the investigation was conducted. And they have alleged that those recoveries were made from the home of the appellants, my lordships. From the home itself of the appellants. They have asked the police officers to follow them and enter into the house of Lakappa, Srimant and all these persons. And they have said that they themselves have removed all the items, MOs and all, and showed before the police officers. And those witnesses before whom they have given such confessional statements as alleged by
Must be
those
given before the police
witnesses
officer.
have turned hostile, my lords.
The confession has to be made before the police officer.
Please, my lords.
So under section 27, how much information can be believed? Section 27. That
Please,
is only in
ma'am.
respect to the recovery portion.
Recovery
So that
portion.
is the recovery. Only we are not relying the entire confession statement only on the recovery. Section 27 of Evidence Act.
It's only discovery of fact
Facts, my lords.
on the basis of that statement.
Yes,
Only
my
that
lords.
portion.
That portion, my lords.
So you cannot enlarge it into any confession. Only that portion has been relied on.
Yes, my lords. Yes.
But I have appreciated your argument. If it
No.
is the police laid hand on the accused only based on the voluntary statement
Yes, my
of co-accused or any other thing. Now the eyewitness are there. No?
please, my lords.
PW4 is the injured eyewitness.
Yes, my lords.
So only recovery portion is concerned. Now 27. That much will be. Yes.
And exhibit P4, my lordships. In the inquest Panchanama, it is said that ಈ ಭಾಗದಲ್ಲಿ ಫ್ರಮ್ ಕುತ್ತಿಗೆಯಿಂದ ಸೊಂಟದವರೆಗೆ my lordships. ಈ ಭಾಗದಲ್ಲಿ ಮೃತನು ಬಿಳಿ ಶರ್ಟ್ ಧರಿಸಿದ್ದು, ಒಳಗಡೆ ಬಿಳಿ ಮುಂಡಿ ಚಾಟಿ ಧರಿಸಿದ್ದು, ಅವುಗಳ ರಕ್ತ ಸಿಕ್ತವಾಗಿದ್ದು, ಅವುಗಳನ್ನು ಸಡಿಲಿಸಿ ತಪಾಸಿಸಲು ಈ ಭಾಗದಲ್ಲಿ ಯಾವುದು ಕಚ್ಚು ಪೆಟ್ಟುಗಳು ಕಂಡು ಬರಲಿಲ್ಲ my lordships. It is cited in the inquest, my lordships. And my lordships, in inquest Panchanama, the exhibit P11, my lordships, page 35 of the paper book, my lordships, they have alleged that before the home of the Lakappa, A2, the offense has taken place, my lordships. My home is behind the home of the Lakappa, my lordships. Srimant, A1, my lordship, appellant home. No home, no name of any of the appellant is mentioned in this sketch map, my lordships. Sketch map of the
Whether it is required, sketch map ಅಲ್ಲಿ ಬಯಸಿರಬೇಕಂತ.
they have shown that before the house of these two persons the incident has taken place. Lordship,
Now,
those.
P2 is the spot hazard.
Yes, my lord.
Then subsequent the engineer AWE has given a sketch. Then RO are issued by the village accountant. What else is required to prove this spot?
Yes, my lords.
ಅದರಲ್ಲಿ ನೇಮ್ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅಂತ your argument.
Yes, my lords. One last point, my lord. In inquest, they have shown 3 major injuries mentioned in the Panchnama, my lords. When they have seen the deceased, my lords. Only 3 injuries they have shown in that.
Inquest Panchanama.
Yes, my lords. And those, as even I have concerned the doctor, those 3 injuries are injury number 22, 27 and 22, my lords. They are punctured laceration wounds, my lords. Those can be very grievous, my lords, according to the doctor.
So yes.
Lords, when they have shown only 3 punctured, how did these 29 injuries occur? My
It is
contention.
not mentioned in the inquest Panchanama.
Yes, my lords. Only 3 injuries. Yes, my lords.
Is it so, Mr. Anil?
Yes, but Lords, the purpose of inquest under section 174 is to find out the apparent cause of death, whether it's homicidal, suicidal, or accidental. That is the purpose. The post-mortem autopsy report would overtake the inquest proceedings.
So doctor stated that some 27 injuries.
Yes, my lords. 29 injuries, my lords.
So we have to give evidentiary value to inquest or PM?
Yes, my lords.
Yes, to which?
Pardon?
The inquest or postmortem?
Both, my lords. Both. I'm not getting yours.
So any other submission? Where another the argument?
And this wife of the
No, you are
injured.
disputing death, sir.
Pardon?
Are you disputing the death? That
No.
is homicidal ಅಂತ ಒಪ್ಪಿಕೊಳ್ತೀರಿ ನೀವು? Is it your case that it's not an homicidal death?
Yes, my lords.
It's a homicidal death.
Yes, my lords.
You are not disputing the death.
I am disputing, my lords.
You are disputing the death. According to you, how the injury is caused? How the injury is caused? According to you? See, if the accused were not assaulted, then who else assaulted? How the injury caused? According to you, what is your explanation? 313 ಅಲ್ಲಿ ಏನಾದರೂ ಹೇಳಿದ್ದೀರಿ? Have you explained in your 313 statement?
No, my lords.
No.
He did not accept the ತಪ್ಪು and
ಅಲ್ಲಿ ಹೇಗಾಯ್ತಂತ
ತಪ್ಪು
injury?
ಮಾಡಿಲ್ಲ ಅಂತ accept
ಮಾಡಿಲ್ಲ
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಂತ.
Yes, my lords.
ಅಲ್ಲಿ ಸತ್ತದ್ದು ಹೇಗೆ ಅಂತವ? ನೀವು ಹೊಡೆದಿಲ್ಲಾದ್ರೆ ಹೇಗೆ ಸತ್ತದಂತ?
Appellant was present, my lord. Appellant was present there, my lord. Actually, he had went to save that person. Actually, my lords. My appellant number 1. My
For
lord.
one,
Yes, my lords.
But how
I am
you
just
overcome
I'm just submitting,
yes,
my
yes.
lords. What my clients,
Yes,
children have submitted me.
how you will
taken to
overcome from the evidence of eyewitness?
Yes, my lords.
There are
And
4 eyewitnesses.
injured wife, my lord, she says, at the moment I received the information that my father-in-law is being assaulted, she did not go to the place of that assaulting place, my lord. She went to the place, she went to inform her husband that my father-in-law is being assaulted by this person. She's not an eyewitness, my lord. She's also not an eyewitness. And the main person, my lords, the person who has come, one Bhimappa Hire Kurbur, my lords, he has come and informed the complainant that your husband is being assaulted over the so and so place, my lords. But he is listed in the charge sheet, my lords, as he is considered as a main eyewitness, but he has not at all examined before the trial court, my lords.
See, exhibit P1 complaint lodged by his wife that
Yes, my lords.
she stated that, yes, Bhimappa informed me.
Yes, my
I
lords.
went to the spot.
Yes,
So in
my
the the said complaint lodged immediately, soon after the incident. In the said complaint also, she stated that, yes, Bhimappa informed me, I rushed to the spot. And thereafter, even otherwise evidence of the injured witness, PW4, he also states.
But
all
he has to be
assaulted.
examined, Alva Ante, sir. His statement is not at all taken, my lords, and he has not at all been examined before the trial court. And the MOs which were brought to the police before the trial court, when they were brought to the
Eyewitness is there, Allah. Rest of the eyewitness, evidence of other witness, other eyewitness,
Yes, my lords.
and injured witness. That is
Yes, ma'am.
sufficient. That
Fine.
is sufficient.
That's all, my lord.
Yes. You argued
Much
well.
obliged, my lords.
Yes,
Much
yes.
obliged.
You argued well.
Thank you, my lords.
Heard for dictating judgment. Yeah. Thursday.
One small request, ma'am. My lords, let it not be observed that I have cited that decision.
Yes, yes.
It's like indirectly saying, maintain the conviction of accused numbers 1 to 4. And obliged, grateful.
Serial number 26, Gaurish Kashampur.
Open mind, go the ಮನಸ್ಸು ಕ್ಲೋಸ್ ಇದ್ದಾಗ ಏನೇನೋ ಫುಲ್ ಪೇಜ್ ಇನ್ನೊಂದು ಸೆಟ್ ಇದನ್ನು ತಂದು ಓದ್ತಿದ್ದೆ Continue. Now we are on the second Yes.
I'll conclude within 1 minute, my lord. Last 2 lines I'll make submission. That word bound is whether it is a mandatory or directory.
No, that will consider.
Please, my lord.
Mandatory. That's mandatory, no doubt.
Once it
10
is
days notice is mandatory.
once it is mandatory,
Mandatory to whom? To the members who give the complaint, not to the AC.
my lord, in
And what 10 days? You don't have to write 10 days. It only means, as held in the first reference, suppose the members give a complaint or whatever requisition. Once you give a requisition, you have to wait for 10 days. You can't go and say AC is keeping quiet. For that limited purpose, 10 days you have to wait. There's no doubt about it.
that is a discussion of judgment, but as per
No
the
discretion.
provision of
No
law,
discretion. They have to wait for the member to enforce it. He has to wait for 10 days. Once the full page is interpreted, we don't know, neither we nor you.
a provision of law, it is not says so.
We can't do anything. They have interpreted in a manner.
Where
saying-
word it is stopped, my lord. 1/3 of the total members and at least 10 days notice has to be given to the intention to the move of resolution to whom anodana
No, that's interpreted in the second one, to the ACN.
in provision of law it is not stated so.
Court, what law lays down, court lists. Yes. Anything else? Our understanding
Law
is
is settled then.
Huh?
Law is settled, there is no need to further.
In second point, my submission may be considered, my lord.
Yes.
Their plain letter they are submitted, my lord. As per the provisions, my lord, they are not submitted requisition, my lord.
Now just take us to the single judge's order.
Please.
Let's have a look at the single judge's order. No, in one of the matters, I don't know, this or the next one, it appears after the interim order was communicated, there was some threat to the government advocate.
In second matter, my lord.
Say, who appears in that?
Government.
No, who are the private parties in that?
Huleppa Heror is appear.
Huh? Huh.
2,29,000 only, my lord. On very same day, they are even locked to the Gram Panchayat. Immediately by 11:30, they are locked to the Gram Panchayat.
They are there before the court, is it?
They are before the court. As a respondent number,
present in the court by any chance?
5 to 8.
No, are they present in the court by any chance? Can you identify them?
But appeared Huleppa Heror, sir, on behalf of.
Now tell us in this.
Please.
Take us to the single judge's order.
Please.
Yes.
It starts from, reasoning starts from para 7, page number 7. Separate I file ಮಾಡಿದೀನಿ along with memo file ಮಾಡಿದೀನಿ. Para 7, it starts, reasoning starts from para 7, my lord. I'll directly come to the reasonings. Page 7, para 7.
Yes.
May I read? The full bench of this court, while considering the question whether the members of Panchayat have to serve a 10 days notice to the Adhyaksha or to the Panchayat or to the Assistant Commissioner, and whether such notice is mandatory or not, held that 10 days notice is to be given to the Assistant Commissioner and not to the Adhyaksha of the Panchayat. After the 10 days notice is given, it is for the Assistant Commissioner to decide the date of the meeting, and therefore the word thereafter cannot be interpreted to mean that the Assistant Commissioner has to wait for the expiry of 10 days and thereafter fix the meeting. The 10 days notice is given to the Assistant Commissioner is to enable him to decide within the 10 days as to how and when the meeting has to be held. That does not imply that he has to commence the process after expiry of 10 days. If the above interpretation of the learned counsel of the petitioner is accepted, the meaning cannot be conducted within 30 days fixed the rule 3(2) of rules 1994. In that view matter, the contention asked by the learned counsel for the petitioner does not merit consideration as a petition.
In the second matter also you appear for the appellant.
Same.
Same argument.
Same argument. There is no. Ali, third day notice ಕೊಟ್ಟಿದ್ದಾರೆ. In this case, first day, very same day.
There is only difference.
There is only difference. On 21st notice submitted and where 21st notice issued. Requisition submitted 21st.
In both the case, common argument.
Common argument. There only change is that.
Then copy is not enclosed.
Please. That is the only difference.
Yes. WA. Yes, serial number is WA 20026 of 25 has been filed challenging the.
So sorry for interrupt, my
by
lord.
the
If that is the case, my lord, your lordship judgment is directly covered.
one.
Your lordship has passed the judgment in writ appeal Dharwad bench, my lord.
Correct. 10 days there.
10 days.
ಇದೆಯಾ ಅದು?
ಇಲ್ಲ ಸ್ವಾಮಿ.
This is ಅಡಿಗ ಜೊತೆ.
ನಿನ್ನೆ ಮಿಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಲ್ಲ.
ಆಮೇಲೆ ಇನ್ನೂ ಒಂದು ಮಾಡಿದ್ವಲ್ಲ ಮೊನ್ನೆ, ಅದು ರೆಸಲ್ಯೂಷನ್ ಕಾಪಿ. ಅದ್ಯಾರೋ ಗಣೇಶ್.
I'll place, my lord. I'll get it and place.
ಇದಾರೆ ಅದ್ರದ್ದಿದೆಯಾ ಅದೇನಾದ್ರು? ಅದನ್ನು ತೆಗಿ. Has been filed by the president of the Tengli Gram Panchayat.
Please.
Challenging the order of the.
In first case, it is in 26 VK Salgar Gram Panchayat.
20029.
29 is in respect of Tengli. ಅಲ್ಲಿ ತೆಂಗ್ಲಿಯಲ್ಲೇ ಇದನ್ನಾಗಿರೋದು. ಅದು ಪಂಚಾಯತ್ ಮೆಂಬರ್ಸ್ ಆರ್ ಅಬ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಟು ದಿ.
Calling in question the correctness of the order in WP 200358 of 2025 dated 6/2/2025, whereby the petition filed by the president of the Gram Panchayat calling in question the validity of the notice issued by the Assistant Commissioner convening a meeting to consider the motion of no confidence has been rejected. Learned single judge had permitted the proceedings in the motion of no confidence to proceed. Said order is in question. Next, in WA 20026 of 25, the resident of the which
VK Salgar.
VK Salgar.
name of the Gram Panchayat
is VK Salgar.
President of the VK Salagar Gram Panchayat has called in question the correctness of the order passed in WP. Where is that order?
That is also placed along with memo.
Separate, is it?
Separate memo.
WP 200360.
Has called in question the correctness of the order passed on 6th February 2025, wherein the challenge to the motion to the notice of the Assistant Commissioner convening meeting to consider motion of no confidence has been rejected. It is noticed that both the orders of the learned single judge are almost identical.
Please.
Both the orders of the single judge.
Almost.
Huh?
Almost.
And address common legal questions relating to the scope of the first proviso to section 49(1) of the Karnataka Panchayat Raj Act. And accordingly, both the appeals are taken up together and disposed of by common order.
Not common order.
It's not commoner.
Common order ಇಲ್ಲ ಇದೆ, separate order ಇದೆ.
Can we dispose it of by common order?
Yes, my lord, can be.
The reasoning,
But law, point of law may be same, but the facts may differ, my lord.
no, correct. That will mention.
Please.
In the facts, we'll mention one paragraph of the dates and then common reasoning. Identical orders. Next. The parties are referred to by the rank in the writ petition. Insofar as WP 200358 of 25. The members of the Gram Panchayat had made out a requisition dated 23/1/2025 to the Assistant Commissioner expressing their intention to move a motion of no confidence. The third respondent, Assistant Commissioner, had issued a notice dated 24/1/2025.
Please.
Convening the meeting to consider the motion of no confidence as 13/2/2025 at 11:30 p.m. They said notice issued by the Assistant Commissioner had been challenged before the learned single judge. In WP 200360.
Page number 33.
Page
33, my lord.
petition copy.
Annexure B.
Page 20. In WP so and so, Savitri, the president of the VK Salagar Gram Panchayat, was elected as the president of the Gram Panchayat, and on 7/11/2024, members of the Panchayat had submitted a requisition to the Assistant Commissioner alleging that they are not satisfied by the administration of the Adhyaksha of the Panchayat, and accordingly had expressed their intention to move motion of no confidence. On 11/11/2024, the Assistant Commissioner had issued notice and meeting was fixed on 30/11/2024 at 3 p.m. The validity of such
ಅಲ್ಲ ಸ್ವಾಮಿ ಅದು earlier ಇದನ್ನ ಬರ್ದಿದ್ದೀನಿ
Previously, there were two writ petitions, my lord.
this is in second round of litigation. ಇದರಲ್ಲಿ on 22/1/2025 called in question the notice date.
Just one. Page 16
Please,
in writ appeal
please.
is the petition copy.
Petition copy, I have stated that in earlier round of litigation, story I have stated in the writ appeal.
In that petition, my lord, kindly see the order of this bench also is there, my lord. In writ appeal number 20015 of
From serial number 6, list of dates.
Huh.
Page 17, serial number 6 in the na.
6, my lord.
Huh?
Page 17.
ಇಲ್ಲ ಮೇಲೆ 6 ಇಲ್ಲ.
ಇಲ್ಲ
of
ಸ್ವಾಮಿ,
date-
ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಗೆ
18.
18 ಇಂದ ಸಾರಿ 22.
Page?
It is in page number 32 and 33, my lord.
ಅಲ್ಲ, ನಿಮ್ ಲಿಸ್ಟ್ ಆಫ್ ಡೇಟ್ಸ್ ಇನ್ ದ ರಿಟ್ ಪಿಟಿಷನ್ ತಪ್ಪ ಅದು?
List of dates ಅಲ್ಲಿ earlier there was 3 rounds of litigation.
Forget about the earlier.
Yes, yes, yes.
ಅದೆಲ್ಲ
But in this requisition was made on 22nd January.
Where is that in the list of dates? ಇಲ್ವಾ ಅದು?
ಅವ್ರು ಹಾಕಿಲ್ಲ ಅವರು.
ಇಲ್ಲಿ ಅದು ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. ಹಾ.
So that, where is that narration? Where do you get it?
Page number 32 and 33, my lord.
32
and 33. 33 is the requisition dated 22/1/2025. Page number 33.
I think the other facts ತೆಗೆದ್ಬಿಡಿ. In WP 200
360.
21. In WP 200360 of 2025, the president of the Gram Panchayat who was elected was subjected to a requisition by members of the Gram Panchayat, moving a motion of no confidence by notice it to the Assistant Commissioner. Full stop. The Assistant Commissioner on 22/1/2025
Please.
had issued notice convening a meeting of the members of the Panchayat on 11/2/2025 to consider a motion of no confidence. The said order has been called in question before the learned single judge. ಇದು 10 ದಿನ ಆಗಿದೆ. Notice 22/1, 11/2. The notice 22/1.
Please.
Okay, notice was issued by the
23,
Very same day, my lord.
23 ಅಲ್ಲಿ
It is
369.
further to be noticed that the notice by the Assistant Commissioner upon the requisitions of members came to be issued on
23rd.
23/1/2025.
ಅಲ್ಲಿ
1 case ಅಲ್ಲಿ, my lord, they are issued notice.
Second,
Second ಅಲ್ಲಿ very same day, my lord.
22 na 23
22, my lord.
22/1/2025.
Morning they are submitted, afternoon they are issued notice.
The common contentions raised in both the writ petitions were essentially that in terms of section 49 first proviso, the requisition submitted by the members must be with clear 10 days notice, and same could not have been taken note of by the Assistant Commissioner prior to the expiry of the 10 days. Full stop. Accordingly, it is contended that the entirety of the proceedings of the Assistant Commissioner issuing notice before the expiry of a period of 10 days as contemplated under section 49(1) first proviso of the so and so act would render the entirety of the proceedings starting from the notice by the AC to be defective. Full stop. 2. The second contention raised in both the matters is that the requisition that is made to the Assistant Commissioner under section 49(1) of the Act is required to be accompanied by the proposed motion of no confidence, and that is the format as is conceived and recognized under the Act and the rules.
1994 94 rules.
Under the 94 rules, and unless such a proposed motion of no confidence accompanies the notice / requisition given to the Assistant Commissioner, the Assistant Commissioner had no jurisdiction to issue notice convening a meeting to consider the motion of no confidence. Full stop. The such contentions were considered by the learned single judge in the order passed rejecting the writ petition. Full stop. In WP 200358 of 2025, the learned single judge has considered had considered the contention relating to the 10 days notice as envisaged under section first proviso to subsection 1 of section 49, and while referring to the contention has laid down that the 10 days notice given to the assistant commissioner is to enable him to decide within 10 days as to how and when meeting was to be held, while clarifying that there is no duty on the assistant commissioner to commence the process immediately. Full stop. The reasoning of the learned single judge is found at para 7 of the order, which reads as follows. Full stop. Next. Insofar as WP 200360 of 2025, identical legal contentions have been raised and addressed to in an identical manner as in WP 200358 of 2025, and the reasoning at para 7 reads as follows. Full stop. Next. Both these orders have been challenged in the present appeals, and common contentions raised as has been raised in the writ petition have been reiterated. Full stop. Next. Learned Counsel Shri Gaurish Kashampur submits that the statutory requirements under section 49(1) first proviso is clear, and there could be no getting over the requirement of giving a requisition to the assistant commissioner as envisaged under section 49(1), signed by 1/3 of the members, to be presented to the assistant commissioner by 2 of the members who have assigned, and such requisition is to be accompanied by a copy of the proposed motion of no confidence. Next, it is submitted that by virtue of the order, by virtue of the reference answered by the larger bench in the case of Hanumava, isn't it?
Shankar Gowda and Hanumava.
No, correct. But your thing is the second one.
Yes, yes.
In the case of Hanumava versus Assistant Commissioner and others, WP 102077 of 2022, it is clear that the notice with the period of 10 days is mandatory, and accordingly it is submitted. If that were to be so, and which is in consonance with the plain wordings of section 49(1) proviso, the assistant commissioner's notice within 10 days of the requisition is to be held to be bad in law. Next, it's submitted that the learned single judge has not appreciated the content, the discussion and conclusion arrived at by the full bench in Hanumava's case. Next, heard learned counsel so and so appearing for the respondents in both of you have appeared in.
ಇಲ್ಲ in one of the case I am 26 ನಲ್ಲಿ ನಾನು
229 respondent number 8 on behalf of Hulap Heru.
Sri Hulappa Herur and so who appeared on behalf of the respondents in the writ petitions and have advanced common arguments. It is contended by them that the question is not left open as heard also learned government advocate Shri Mallikarjun Basireddy on behalf of the state. The contention of the members as well as the government advocate are in tandem and to the effect that the legal question that is sought to be canvassed has already been covered by the reference to the to the larger bench in WA 20087 of 2022 as well as the reference in WP 102077 of 2022. It is submitted that the reference in the full bench as in Shankar Gowda's case has upheld the judgment of the division bench in M. Puttegowda's case and refused to reconsider the decision in Puttegowda's case. Full stop. Next, it is submitted that the division bench in M. Puttegowda and another versus Assistant Commissioner in WA 4366-67 of 2001 disposed of on 6th August 2001 after a detailed consideration had reiterated the law laid down in Parvati versus Assistant Commissioner Haveri 1998 1 KLJ 399 and held that no doubt there is a requirement for the members who move the requisition to give at least 10 days notice to the Assistant Commissioner, but however it would not, the 10 days notice would not come in the way of the Assistant Commissioner to call a motion to call a meeting to consider the motion of no confidence before the expiry of 10 days. Accordingly, it is submitted that no further question remains to be adjudicated and the full bench references referred to above clarify that no doubt it is mandatory for the members giving the requisition to give a 10 days notice. However, Assistant Commissioner can act even within the said 10 days. Full stop. Accordingly, it is submitted that the learned single judge has come to a correct conclusion and in fact referred to the reference in Shankar Gowda's case and there is no case made out for interference. Full stop. Next, heard both sides. Section 49(1) of the Act reads as follows. Next, Rule 3(2) of the 1994 rules reads as hereunder. Next, the only contention raised by first contention raised by counsel for the petitioners is that under section 49(1) of the Act, the members who give the requisition are required to give at least 10 days notice of intention to move the resolution. Full stop. The point that is canvassed is that in light of the requirement of 10 days notice to be given to the Assistant Commissioner and as the full bench had in Hanmava's case had clearly observed that the 10 days notice was mandatory, whether the action of the Assistant Commissioner in issuing notice convening the meeting immediately thereafter, that is within the period of 10 days, without waiting for the 10-day period to lapse, could stand scrutiny. Next, it must be seen that the very question that is raised had been a subject matter of reference in two matters. Full stop. In the reference in the case of in the case of Shankar Gowda's case in writ appeal 200087 of 2022 was answered on 22nd July 22, which is the first order of reference. Full stop. The question for reference raised in Shankar Gowda's case, which page?
Page number 17 for 24, my lord.
Page
23. Of
Sir, where
judgment.
is the question frame?
The question is in page number 4, my lord.
Page number 4.
4.
Question raised in case of Shankar Gowda's case. ಇದು page 4 ಅಲ್ಲಿ
Last 3 lines in the Shuragats.
is as follows. Para 2 above italics. It must be noticed that what was doubted leading to the reference was ratio laid down in Putte Gowda's case, and accordingly the question for reference was whether the law laid down in M. Putte Gowda's case required reconsideration. The conclusion by the full bench is at para 19, which reads as follows. Full stop. The relevant observations made we'll say from para 15.
Please, man.
Huh?
16.
15.
15 and 16, 17, my lord.
16, 17 is the relevant paras. 15 ಗೆ discussion ಇದೆ. 16,
15 to 17.
Please.
Reads as follows. Next. It is thus apparent that in the reference the court has held that the notice no doubt is mandatory. However, that would not hold the hand of the assistant commissioner, who could act even within the period of 10 days. And there was no compulsion on the assistant commissioner to wait for the expiry of 10 days. Full stop. It is necessary to notice the reasoning at para 15 as extracted above, and it is observed and pointed out that the period of 10 days is notice period to be given to the assistant commissioner vis-a-vis the members giving the requisition. Full stop. It is observed that the members, after giving the requisition, must wait for the period of 10 days, and if even on the lapse of 10 days no action is taken, they may be in a position to challenge inaction of the assistant commissioner, but cannot take any action prior to the expiry of 10 days. Having said so, it was further clarified that this notice waiting period of 10 days vis-a-vis the members of the Gram Panchayat would, however, not cast an obligation on the assistant commissioner to wait for the expiry of the period of 10 days. And the assistant commissioner could, depending on his administrative convenience, act even within the 10 days. Full stop. The second order of reference was in WP 102077 of 2022, dated 8th August 2022, in the case of Hanumava. The order, the question for reference
Page 11.
is at page 11 full stop, and is extracted below. The two questions that were raised while framing the question of reference is one, as to whether 10 days notice prescribed in the latter part of first proviso to subsection 1 of section 49 is to be given to the Adhyaksha of the Gram Panchayat or Assistant Commissioner. 2. Whether such notice is mandatory or directory. Next. Insofar as the first question is concerned, the full bench has held that the notice contemplated to be given only to the Assistant Commissioner and not to the Adhyaksha. The relevant observations as regards such aspect is at paragraph
17.
Paragraph 17. Paragraph 17 is extracted below. Full stop. Now, insofar as the second point is concerned, as to whether the Assistant Commissioner has to wait for the expiry of 10 days, reference is answered by relying on the reference in Shankar Gowda's case. The conclusion at para 18 reads as follows. Next. The answer to the reference is found at para 19, which reads as follows. The answer to the reference must be read in conjunction with the observations made at para 18. Full stop. If that were to be so, the reference in Hanumava's case has reiterated the answer to the question of notice, 10 days notice being mandatory or directory by relying on the reference in Shankar Gowda's case. Full stop. Next, in fact, it is clear that in Shankar Gowda's case, the decision in Putte Gowda was held to be correct and required no reconsideration. The observation made by the division bench in Putte Gowda's case at paragraph
8, my lord.
8 reads as follows. The same is clear and reiterates the law laid down by the single judge in Parvati's case. And accordingly, we find that the order of the learned single judge is in consonance with the reference by the full bench in Shankar Gowda and Hanumava's case. And accordingly, appeals are rejected.
One more submission, my lord. Now, since by the virtue of operation of this stay order by this court, my lord, the Assistant Commissioner has not yet decided the date of the no conference, my lord. So if there is direction to the Assistant Commissioner to hold the meeting at so and so date, it may be.
In light of dismissal of the writ petition and upholding the order of the learned single judge, the Assistant Commissioner now is to proceed from the stage of
My lord, no conference motion.
ಈಗ ಮತ್ತೆ ಅವ್ರ ನೋಟಿಸ್ ಕೊಡ್ಲೇಬೇಕಾಗುತ್ತೆ ಸ್ವಾಮಿ, because without notice they can't hold an
Assistant Commissioner.
as per
no, there is some rule, isn't it?
Yes,
If there is a stay, then it must start from the
ಅದು ನಿಂತ ಈಗ again my lord, as per provision is clear, my lord.
What
Rule
does it
3,
say?
my lord.
Rule 3 ಈಗ without issuing notice, once it is postponed, my lord.
No, what does it say?
Please, my lord.
Rule 3.
Rule 3, my lord.
Proviso Rule 3 ಅಲ್ಲಿ proviso.
Huh?
Rule 3 of the 1994, my lord.
ಅದು only for 30 days ಗೆ rule 3 applicable, my lord.
No, we'll see what it says.
ಹಾ.
What does the rule say?
Rule 3, my lord.
Rule 3 proviso, my lord.
No, rule 2 proviso.
Rule 2 rule 3 to proviso, my lord.
Rule 3
Read 2 proviso.
Yes, my lord.
Provided
Provided that whether the holding of
Such meeting is stayed by an order of a court, the Assistant Commissioner shall adjourn the said meeting and shall hold the adjourned meeting on a date not later than 30 days from the date on which he receives the intimation about the vacation of stay, after giving to the members after a notice of not less than 15 clear days of such urgent meeting.
Yes.
Okay, now we'll pass a direction that in terms of Rule 3(2) proviso,
Yes.
Assistant Commissioner is to proceed.
Please.
And taking note that the Rule 3(2) proviso contemplates of a situation where there is a stay of the process by order of court and the consequence of lifting of stay. The Assistant Commissioner is to take steps in accordance with the proviso to Rule 3, Sub-Rule 2 and proceed further to convene a fresh meeting.
Please, much.
Grateful.
If the copy is made available, my lord. Yes, ma'am. Thoughts? One request, lordship, one humble request.
That affidavit, I think the AG has taken note of it. So that affidavit, Tengli has filed some affidavit.
Yes, ma'am, that is why I want to bring to lots of
No,
notice.
correct, but I think the AG has taken note of it. AG has taken note of it. So we will see. If a formal requisition comes, we'll take it up.
I don't know whose client, my lord, I don't know, my lord. Maybe that,
Even they are locked to the Panchayat also, my lord.
They rushed to the
Even we are
chamber
made a complaint.
they rushed to the chamber
Correct,
and threatened to the, my lord, colleague, saying that where is the written order you submit. But lordship, on that time, my lord, I was also here, my lord.
Correct.
Orally, lordship directed my colleague to intimate to the Assistant Commissioner. That was done by. They should not come to the chamber, my lord.
No, absolutely.
Maybe they are their own advocate, they can make submission before the
Your
court.
party is present.
No,
Huh?
not present.
Even
Advise them that is highly improper. Now,
for locking of the Gram Panchayat.
now just look at it, irrespective of the merits. Government advocate, now we can't release the order immediately. We ask the government advocate to intimate telephonically. How you can take offense to it? Now, no doubt you may be frustrated because several rounds of litigation. That's the process of the court. We stayed it. Today we are giving full relief. That's how the system works. You must advise them properly. We have to. The AG happened to speak. I have told him you take appropriate steps. We'll take note of it.
If the operative portion of this order made available today or tomorrow, my lord.
No, we'll release it once. ತಿರ್ಗಾ ನಾವು ಆಪರೇಟಿವ್ ಕೊಟ್ಟು ಅದಕ್ಕೆ ಕನ್ಫ್ಯೂಷನ್ ರೀಸನಿಂಗ್ ಸರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅವನದೇ ಒಂದು ರೀಸನಿಂಗ್ ಕೊಟ್ಟು release it.
Please, much.
Even if it takes a few days, better let everything be clear.
Please, much.
Please continue.
Number 27, PV Dalde.
Appearing for appellant, my lord. Senior counsel is in VC.
Till number 27,
Senior counsel.
Appearing for the appellant's counsel.
Yes. Yes.
The petitioner is the appellant.
Let notice go. We'll direct notice on the.
The state is the only contesting respondent. It's a land acquisition matter. Challenging the validity of the acquisition. During the pendency, my lord, it appears the award is passed. The learned single judge holds that the writ petition has become infructuous. So that is not correct, my lord, is our respective submission.
Yes. We'll ask them to. No, it requires consideration.
Yes, it requires consideration.
Yes. AGA, GA, we directed to accept notice For respondents 1, 2, 3. Your challenge to it was within time.
Yes, my lord, there was no difficulty about it, my lord.
It
The
was not-
statement
it was
of
not-
objections are filed, a copy of the award is enclosed, and it is stated it has become infructuous. But what should happen to my cause, my lord, in the writ petition as far as the merits of invoking the power of eminent domain
Yes, yes.
without a public purpose?
Yes, yes.
Your
You have
lordship
served
will kindly
copies.
see, my lord, the section 4, my lord, the notification. It is so vague, my lord, the purpose for which it is sought to be acquired.
We'll consider it.
Please.
You serve copies. Copies to be served on GA. List week after next. Yes.
Obliged.
Number 28, Basavalinga Nasi.
I appear for the proxy, my lord. And next week, my lord, next Tuesday, my lord.
You notify after 2 weeks.
My lord, it is interim application, my lord. And kindly
28, serial number 28.
28, my lord, Basvalinga Nasi.
Huh?
Basvalinga Nasi, my lord.
Huh.
It may be taken on Tuesday, my lord.
Oh, Tuesday.
For objection.
Suspension sentence is filed, my lord.
He needs to file objection week after next 45 days.
Yes.
In the meantime, learn the additional explication. Directed to file objections if any to IA 1, 2 of 20.
Number 29, Liaquat Farid Ustad.
Lord, this is appeal by the accused number 5. Lord.
Please to respondent number 2. Please respond learn the SPP is directed to take notice for respond number 1. List this appeal after service of notice to the respond number 2.
Please.
Meantime, registry is directed to security CR.
Please.
What is surviving?
Please.
Number 30,
SCST.
Manvendra Reddy.
In appeal filed by insurance company, there is a delay in filing the appeal. It's a case of a contributing negligence. I'll deposit 50% of the amount before this court.
Delay working stay model.
Delay in strict sense, there is no appeal in IF law. I'm conscious of it, but still this being.
Manvendra Reddy appears to the public interest.
No, law is, I cannot be.
Keeping open for the aspect of delay. The operation and execution of the impugned award passed in MUC number 301 of 2023 by the MACP 5 Vijayapura dated 12/6/2024 is stayed subject to appellant depositing 50% of the award amount before this court within a period of 4 weeks. Just notice, issue notice to respondents. Registry is directed to secure the trial court records.
Number 31, Rupa Sagar Patil, Nitesh Padilla.
This is a status matter, my lord. Compassion appointment.
Tell us the facts.
My lord, the facts are, my lord, the deceased one, Basuraj, was working in the JESCOM, my lord. He died on 2/1/2005.
Just on.
Yesterday it was heard, my lord, for
Dictate ಮಾಡಿದ್ದಲ್ಲ. Yes, tell us the fact.
My lord, one Basuraj K
Uh,
was working in the Jascom, my lord. He died on 2/1/2005.
He died on?
2/1/2005.
Uh,
My lord, on 17/6/2005, the first petitioner gave gave a representation at annexure A.
Representation by the mother.
Yes, my mother, at annexure A, page 35 is the typed copy.
Page?
35, typed copy, annexure A. Stating that our son is minor. ನಾನು ಶ್ರೀಮತಿ ಹುಲ್ಗೆಮ್ಮ ಗಂಡ ದಿವಂಗತ ಕೆ ಬಸವರಾಜ್ ಇದು ನನ್ನ ಗಂಡನು ದಿನಾಂಕ 2/1/2005 ನಿಧನ ಹೊಂದಿದ್ದರು. ನನ್ನ ಮಗನಾದ ರಾಜು ಎಚ್ ತಂದೆ ಕೆ ಬಸವರಾಜ್ ಇವರು ಚಿಕ್ಕ ವಯಸ್ಸಿನಲ್ಲಿರುವ ಕಾರಣ 18 ವರ್ಷಗಳ ತುಂಬಿದ ಬಳಿಕ ನೌಕರಿಗಾಗಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸುವುದಕ್ಕೆ ಅನುಮತಿ ನೀಡಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸುತ್ತಿದ್ದೇನೆ. This is the representation given by the mother. That is petition number 1.
Yes. Yes.
My lord, later on it is alleged that at annexure C, they were given a representation dated 15/8/2008/16/8/2008 by the fourth petitioner, that is the son. If lordship permits, I may read. Annexure C, page 37. Dated 15/16/8/2008, which doesn't bear the endorsement of the JESCOM.
Yes.
Lord, I am permitted to read. ಈ ಕೆಳಗೆ ಸಹಿ ಮಾಡಿದ ನಾನು ರಾಜು ಎಚ್ ತಂದೆ ಬಸವರಾಜ್ ಕೆ ಸಾಕಿನ್ HR/S ಕಾಲನಿ ಗಂಗಾವತಿ ಜಿಲ್ಲೆ ಕೊಪ್ಪಳಿದ್ದು ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ವಿನಂತಿಸಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ನನ್ನ ತಂದೆ ಬಸವರಾಜ್ ಕೆ ತಮ್ಮ ಇಲಾಖೆಯಲ್ಲಿ ಡಿ ಗ್ರೂಪ್ ನೌಕರನಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವಾಗಿ ದಿನಾಂಕ 2/1/2005 ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ಮೃತರಿಗೆ ನಾನು ವಾರಸನಾಗಿದ್ದು ಸದರಿ ನನಗೆ ಅನುಕಂಪ ಆಧಾರ ಮೇಲೆ ಉದ್ಯೋಗ ನನ್ನ ತಂದೆಯ ಮರಣೋತ್ತರ ಅನುಕಂಪ ಆಧಾರ ಮೇಲೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಳ್ಳಬೇಕೆಂದು ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇನೆ. This is the only letter, my lord, where he even doesn't state on what date he has become major. Straight away, this copy is produced in the petition, which does not bear the seal of the JESCOM, my lord. My lord, at annexure D, it is submitted, my lord. They have given one more representation on 23/3/2013. An order is passed rejecting the application for compassion appointment on the ground of there is a delay of 7 years, 9 months, 24 days in making an application.
Annexure D.
D, my lord.
That is the endorsement.
Endorsement, my lord. We have stated, my lord, that the
Read the endorsement.
My lord, ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಮತ್ತು ಉಲ್ಲೇಖಗಳಲ್ಲಿ ಸಂಬಂಧಿಸಿದಂತೆ ದಿವಂಗತ ಕೆ ಬಸವರಾಜ್ ಸೂಚಿಗಾರರು ಕಾರ್ಯ ಮತ್ತು ಪಾಲನೆ ಉಪವಿಭಾಗ ಜೆಸ್ಕಾಂ ಗಂಗಾವತಿ ಇವರು ದಿನಾಂಕ 2/1/2005 ಮೃತ ಹೊಂದಿದ್ದು ಇವರು ಮಗನಾದ ಶ್ರೀ ರಾಜು ಎಚ್ ಆದ ನೀವುಗಳು ಅನುಕಂಪ ಆಧಾರ ಮೇಲೆ ನೌಕರಿ ನೀಡಲು ದಿನಾಂಕ 26/10/2012 ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವಿರಿ. ಆದರೆ ನೌಕರನು ಮೃತಪಟ್ಟ 1 ವರ್ಷದೊಳಗಾಗಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಬೇಕಾಗುತ್ತದೆ. ಈ ವಿಷಯದಲ್ಲಿ ನೀವುಗಳು 7 ವರ್ಷ 9 ತಿಂಗಳ 24 ದಿನಗಳಷ್ಟು ವಿಳಂಬವಾಗಿ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುವುದರಿಂದ ಉಲ್ಲೇಖ 1ರ ನಿಗಮದ ಅಧಿಸೂಚನೆಯಂತೆ ಅನುಕಂಪ ಆಧಾರ ಮೇಲೆ ನೇಮಕಾತಿಗಾಗಿ ಸಲ್ಲಿಸಿರುವ ನಿಮ್ಮ ಅರ್ಜಿಯನ್ನು ಪರಿಗಣಿಸಲು ನಿಗಮದಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ.
Where is this 26/10/2012?
My lord, that copy they are not produced.
But it was given to you.
Yes, my lord. That is there. There is no dispute. There is no dispute, my lord. In inverted
According to you, it was given only
yes,
on?
it was given on. It was given on 26/10/2012.
By him?
Yes, my lord.
That is the son?
Yes. Now, my lord, this order was challenged before the learned single judge in the writ petition number 204232 of 2014.
Yes.
Which was allowed. My lord, if lordship permits, I may read the relevant portions, my lord, at para 15, page 22. Page 22, para 15. My lord, the petition number 4 attained majority and is
from para 14.
Please, my lord. Having considered the said request dated 17/6/2005, Exposing the same with amended Rule 5, I am of the considered opinion that there was no requirement for respondent to reply the same, since there has been no appointment sought to be made on 17/6/2005. The question of appointment being made only arises on an application being made in compliance of the regulation consideration of the candidature of the state person making such application. There has been no candidature on 17/6/2005. There was no requirement for the respondent to reply the same. The petition number 4 attained majority and is stated to have been made an application on 16/8
no candidature on 17/6/2005, there was no requirement for the respondent to reply the same. That means, my lord, for the undisputed period, that is 17/6/2005, we have made the representation. Claim has been made way back in the year 2005 itself.
By the mother.
By the mother. Since all four are dependents, that is not in dispute, and all the four petitioners, that is respondents, were parties to the writ proceedings, my lords.
What is the rule applicable?
Pardon, sir?
What is the applicable rule?
I will come to that. Because, my lord, it is an industry. What were the law and regulations as on the date of the death of my father, that is at the time of employment of my father, those rules will be applicable till his death. Though it may look a little absurd, my lord, I am fairly conceding. But it was not brought to the notice of any honorable court. There are conflicting judgments, my lord.
Santosh case.
ಅಲ್ಲ ಸರ್, ಇನ್ನೊಂದಿದೆ ಸರ್. ಇದರಲ್ಲಿ in case of, it is an industry. Even for transfer also, there it may not be possible. What the division bench of this honorable court was pleased to hold. At the time of appointment, there cannot be change of service condition contrary to section 9A of Industrial Disputes Act.
This point has been considered, I think, in Santosh case, Apex Court. Anyhow, we'll, for a moment, we'll take that the law prevailing as on the date of death.
Allah, sir. As on the date of I joined the service, and even as on the date of death, my submission, it may be extended even till my death, but my submission, as per this decision which I have submitted,
There cannot be alteration in conditions of service.
yes, my lord. Since in this case, my lord, he was employed in Bangalore.
No, we'll accept that.
Sir.
We'll take it at that.
Please. So the submission of my friend, and in other cases, my lord, fairly, I am conscious of other judgments too, dealing with Rule 5 of KCSR. It is an industry. KEB, it is an industry, my lord. My humble submission would be, these service conditions which were there in existence as on the date of appointment of my father, they remain same, and they cannot be altered unilaterally, violating section 9A of Industrial Disputes Act. Change of service conditions cannot be done. It may be applicable to all other persons who are appointed subsequently.
Now, under the existing rule, application shall be made within a period of 1 year after attaining majority.
Sir, that existing rules means that they have adopted, my humble submission, my lord, that cannot be adopted. Contrary to
that, we cannot enter into.
No, I will pursue your lordship. Kindly.
No, that's not the case made out before the single judge.
Sir. What my learned friend is submitting, that within 1 year it has to be made as per
that is the rule.
Sir, even assuming that, I have made the application on 17/6/2005. It is not being disputed by the other side.
That's by your mother, not the.
Yes, my lord. Mother means, since I was a minor.
The correct rule says within 1 year of attaining majority, you have to give. Have you given?
But I am coming to that point, my lord. The only submission of my friend is that Annexure C is got up. They are not disputing insofar as Annexure A is concerned.
But how did the single judge observe there's an endorsement on the application?
Pardon?
How did the single judge observe of the endorsement?
I am not, I will come to that point, my lord. Your lordship, Annexure C may kindly be perused.
Yes. Yes.
It bears the date, Mele sir, 15/8/2008, ಕೆಳಗಡೆ ಅಂಡರ್ಲೈನ್ ಮಾಡಿ 16/8/2008. My lord, my humble submission, what I am trying to pursue your lordship is, the learned single judge has been pleased to take into consideration that they are hailing from village, rustic villagers, illiterate persons, etc. So my submission would be, my lord, we make an application. We will not be knowing. We get it prepared early. It is a village, my lord, hatti.
No, there's no dispute of this, sir. But where is the endorsement?
I am coming to that point, sir. Other ledger, your lordship may kindly.
No, ledger was not there before the single judge. Forget about the ledger for a moment.
Yes, ma'am. Endorsement says.
Where is the endorsement before the single judge?
Other note, one minute. Let me have a glance.
Single judge records could.
ಅದೇ ಅಸಿಸ್ಟೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಇದೆ ಸರ್.
ಎಲ್ಲಿ
ಡೇಟ್ ಇಲ್ಲ. ಅದೇ annexure ಅಲ್ಲಿ
ಯಾವ್ದು
ರೈಟ್ ಟು
annexure ಸಿ ಮೇಲೆ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಒಂದ್ ನಿಮಿಷ.
That the single judge says endorsement is there.
ಅಲ್ಲ ಸರ್, this application moved under right to information is there, my lord. Signature of the receiving clerk is there. Insofar as my application is concerned under the right to information, RTI Act.
No. The single judge says, though annexure C has no endorsement, application is filed under a memo which bears endorsement of the respondent to be received on 17/8. Where is that?
ಅದೇ ಸರ್ ನಾನು ಹೇಳೋದು. ಇದರಲ್ಲಿ 17/8/2008 ಅಂತಿದೆ ಸರ್.
What is that document?
It is not document, my lord. It is application which I have moved for furnishing the under the RTI Act. One ನಿಮಿಷ. Under right RTI Act, my lord, I have moved the application. The receiving clerk gives endorsement dated 17/8/2008. ಇಲ್ಲ. The application which was moved under the RTI Act.
What is this RTI form for what?
ಅದೇ ಸರ್, ನಾನು ಅಪ್ಲಿಕೇಶನ್ I am hesitating for my rights. And he says, my lord, your lordship, I kindly appreciate my submission. Last ಪ್ಯಾರಾದಲ್ಲಿ I am seeking employment ಅಂತ ಇದೆ ಸರ್.
No. There must be an endorsement on annexure C, isn't it?
Sir.
Where is that?
Annexure C ಅಲ್ಲಿ endorsement ಇಲ್ಲ.
Then now we can take.
Yes, my lord. It is not there, but insofar as my application which I have moved under the RTI Act, there is endorsement of receiving clerk. Receiving clerk, I leave it to the honorable court, my lord. Receiving clerk signature is there and he writes 17/8/2008.
What is this? This is only an RTI.
RTI applications. Now I will come to the moot point, my lord.
No, this original you have this original.
Illa, sir. Your lordship may kindly appreciate my submission. They are literate or semi-illiterate, sir. They are hailing from rustic.
Maybe ರಿಜಿಸ್ಟರ್ ನೋಡಿದ್ದೀರಲ್ಲ?
ಇಲ್ಲ sir. I am coming to that point, my lord. Kindly bear with me. Sir, they say that they admit that I have given a representation. It is not in dispute that I have not given representation at all. They say that I have given the representation. The defense is the date on which I have given the RTI application. On that day, it was Sunday.
RTI ಅಲ್ಲ.
ಅದೇ sir, ಅದೇ annexure C.
Forget about annexure C.
Please.
In the register, Tapal register. There is no entry.
ಅದೇ sir, ಅದೇ ಅದು ಎಂಟ್ರಿ ಇದೆ ಸರ್, ಓವರ್ ರೈಟಿಂಗ್ ಅಂತ ಅಂತಾರೆ ಸರ್.
ಹೌದು.
There is, I will, please kindly. ಕೊಡ. Your lordship, the register, has to be opened with an officer or drawing officer of that subdivision, division, whatever it is. It doesn't bear the signature, the date on which it was opened or closed. What I am trying to persuade your lordship is, if it is concocted, can it be looked into? Your lordship, it is a public office. It is public sector. It doesn't bear the signature on which it has been commenced. Executive engineer, assistant executive engineer, junior engineer, nobody's signature is there. And date code. And my lord, I kept the flags here. I have verified it. There, ಡಾಕ್ಯುಮೆಂಟ್ ಬಂದ ಮೇಲೆ ಅದಾದ ಒಂದು ವಾರ ನಂತರ ದಿ ಡೇಟ್ ವಿಚ್ ಈಸ್ ಮೆನ್ಷನ್ಡ್ ಅಬೌವ್, ದೇರ್ ವಿಲ್ ಬಿ ರೆಫರೆನ್ಸ್ ಆಫ್ ಎ ಡೇಟ್ ವಿಚ್ ಈಸ್ ಸಬ್ಸಿಕ್ವೆಂಟ್.
Somehow we are not convinced by that.
No, I will. It is apparent, my lord.
It's apparent that the only beneficiary of that that alteration is only our client.
ಅಲ್ಲ sir, if your lordship says so. ಇಲ್ಲ ಪ್ರೈವೇಟ್ ನಾ ಹೇಳ್ತಾ ಇದ್ದೀನಲ್ಲ ಸರ್. I am can there be 1/10/2015 ಅಂತ ಲೆಟರ್ ಬರೋದು, ಇದು ಲೆಟರ್ ರಿಸೀವ್ಡ್ ಅಂತ ಹೇಳಿ, ಅದಕ್ಕಿಂತ ಮುಂಚೆದ್ದು, ಆಮೇಲೆ 15 ದಿವಸ ಆದ ನಂತರ ಅದಕ್ಕಿಂತ ಮುಂಚೆದ್ದು ಲೆಟರ್ ರಿಸೀವ್ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಆಸ್ಪದ ಇದೆ ಅಷ್ಟೇ. That apart, five six, my lord, 5/6/11/6/19/6 ಅಲ್ಲಿ ಸಿಗ್ನೇಚರ್ಸ್ ಯಾರ್ದು ಇಲ್ಲ ಸರ್. ಕೆಳಗೆ ಡೇಟ್ ಬೇರೆ ಬರ್ತದೆ ಸರ್. ಹೆಡ್ಡಿಂಗ್ ಅಲ್ಲಿ 5/6/11/6/19/6 27/6/11/7
428 there is no signature.
ಅದೇ ಸರ್ ನಾನು ಹೇಳೋದು, ಇನ್ ಆಲ್ ದಿ ಎಂಟೈರ್ ledger your lordship may kindly peruse. There is no signature of the person.
Signature.
What else?
ಎಲ್ಲದಕ್ಕೂ ಇದೆ signature ಇದೆ.
ಇಲ್ಲ, ಎಲ್ಲದಕ್ಕೂ ಇಲ್ಲ ಸರ್.
ಎಲ್ಲದಕ್ಕೂ ಇದೆ. This is not there.
ಅಲ್ಲ
ಪೇಜ್ ಅಲ್ಲಿ ಎಲ್ಲದಕ್ಕೂ ಇದೆ.
ಆ ಪೇಜ್ ಒಂದೇ ಹೇಳ್ತಲ್ಲ ಸರ್. ನಾನು ವಾಟ್ ಐ
will see, but I'm saying we can't be
ledger as it is, ledger, the veracity of ledger, my lord, the veracity of ledger required to be looked into. Veracity of ledger.
We can't say it's a bogus ledger. Can we say that?
No, my lord, none submission. Your lordship may kindly have a glance on that. Have a glance on that. What I am pursuing, I am trying to pursue your lordship.
No, your point is well taken that all entries don't have signature. Your point
ಆದ್ರೂ ಇಲ್ಲ ಸರ್, ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಆಮೇಲೆ ಡೇಟ್ಗಳು ತೋರಿಸಿದ್ದಾರೆ. Subsequent dates. There cannot be subsequent dates. That apart, my lord, the moot question will be They issued the endorsement.
Yes.
On the ground, my lord, your lordship may kindly appreciate my submission. It is compassionate appointment means, my lord, while interpreting any provisions of law or facts.
No, we can't have compassion when the person, according to us, doesn't come with clean hands.
ಅಲ್ಲ ಸರ್, ನಾನು ಹೇಳೋದು ಒಂದು, I leave to your lordship. If that is the case, my lord, I will not be. Kindly permit me only one sentence. When they say, my lord, that I have given the application on 26/10/2012,
Yes.
should not they produce the same before this honorable court? When they can produce the ledger, inward register, outward register, etc., so-called inward and outward, is it not their duty? They say that I have not produced it. I have not submitted. On 17/8/2008, is it not, they say, my lord, specifically they say, the endorsement says that on 26/10/2012, I have given the application. If that is there, my lord, I may not have the case. I am fairly conceding.